Okay, we're back on the record. What argument do you have, Mr. Rogers?
Thank you. As it relates to the charges against Mr. Craig on the aggravated assault, I would say there's a couple of issues with the whether or not the testimony supports the allegation. For one, the only two people that the officer mentioned talking to were a mother and a daughter, as I understand it. Additionally, the officer couldn't really recall whether or not they had taken any sort of safeguards or anything to prevent one witness's testimony from influencing the other witness's testimony. So the fact that the two are alleged to be consistent with one another is just as much, that's just evidence of listening. That's not necessarily evidence of a factual basis of any sort. There's no independent witnesses being alleged at this point. Additionally, there was no testimony about an age. Like, it was just an allegation that someone was under 18, but there was no specification of any age for anybody.
I think he said under 15.
Okay, I'm sorry. It was scratchy, so that may have been what was said. I would still say that's still not a specification of an age. If you don't know how old somebody is, you can't say how old they aren't. In other words, if you can't say this person is 16, you can't say that person is not 18 if you don't know how old they are, especially once we start getting into 15 to 18. That's an age range that if you don't know how old they are, you don't know how old they are. So for that reason, I would ask that the charge as relates to cruelty to children be dismissed. Because again, I shouldn't say again, but as always, the state has the burden. So we don't have to disprove that they could have been 15. The state needs to have affirmative evidence of some sort. Either somebody told me that, we don't know where he got this from. This could have just been officer speculation. He hasn't offered any basis. He didn't attribute that statement to anyone. So it's unsupported at this point. It's just conjecture. It's not even a fact, as in it's not been asserted by anyone with knowledge of it. Additionally, as it relates to the aggravated assault, the allegations of choking, again, there's no real corroboration. There's no video. There's two statements, which we don't know whose came first. There's no safeguards to ensure any kind of reliability. So the idea that one would be probative or corroborative of another is insufficient. Additionally, when I asked the officer about who struck who first, or as who initiated any kind of altercation, the officer didn't ask that, or at least couldn't testify that they had asked that. So it's not clear how they would have established who was the primary aggressor, which is relevant to an allegation of aggravated assault. She didn't say that it was unprovoked. There was no discussion of how it was proceeded. So what we have is an incomplete story, which is not a basis to allege that Mr. Craig was doing anything other than acting defensively if we don't know who the primary aggressor was. And there was really no testimony or detail to those facts. So for those reasons, Your Honor, both charges be dismissed for lack of probable cause.
Ms. Freeman?
Thank you, Judge. We're asking that both charges be bound over to Superior Court. We believe that it was a complete story. The victim gave the information to Deputy Masonette, and one of the children also corroborated what her mother had indicated had happened and what she observed. The victim's testimony through Deputy Masonette was that she and the defendant were driving, had an argument. She asked him to pull over. When he did, he proceeded to choke her as well as pull her hair. Her 4 juvenile children were in the back of the car. All this happened in Clayton County. We believe is as complete a story as there could be at this stage. And so we're asking that all of the charges be bound over to Superior Court.
Okay, I'm going to find that the evidence is sufficient to bind over the aggravated assault and the cruelty to children in the 3rd degree. I understand your arguments, Mr. Rogers, at this stage is unrebutted testimony, and I understand why it's unrebutted at this stage. So I'm going to bind it over to the Superior Court of County.
Thank you, Judge. And may Deputy Masonette be excused?
Yes, excused. And Mr. Craig can go back.
Thank you, Masonette.
All right, thank you.
And Judge, we have Officer Arnold. She's already on for Javonda Perry.
Yes, let's bring up Miss Perry.
Excuse me, Your Honor.
Yes, sir.
I'm going to ask for a bond on Mr. Craig, partly because I'm looking at his intake date, which is April the 2nd. So he's getting close to 90 days. At this point, he doesn't have a bond on, I think, one of the charges, if I'm not mistaken, on the aggravated assault. I would just ask that the court would entertain setting a bond at this point, since as of July the 2nd, approximately, he'll be due.
I don't think at this stage I can do it without at least 10 days notice to the state. And because there's an alleged victim in this case, I think the alleged victim has to have a reasonable opportunity to be contacted about the request for bond.
Understandable. All right, thank you, Your Honor.
Your Honor,
You're welcome. Yes, sir.
Ms. Perry will be here in 10 minutes. She had to go back
Miss
to the
Perry.
household. Yes,
Can
yes, sir.
Uh,
We still have 3 more.
yeah, who's the officer on Curry?
Judge, we have to get the officer. I had the officer ready on Perry, so
Okay.
didn't realize they had sent her back. And so if you can give me a second, we'll work on getting the officer on Curry.
Okay.
Your Honor, I think we're still showing up live on my phone on YouTube is what it's saying.